Good evening to all of you. Welcome to Legal Matters by Sai Babu Sankara. In this video, we are going to study a case law from the Supreme Court regarding the test identification parade, which is having evidentiary value as per Section 9 of the Indian Evidence Act. But please remember, before conducting the test identification, if the accused were shown to the witnesses, that identification becomes infallible, it becomes inadmissible. Can it happen? Yes, it can. So, Honorable Supreme Court of India, in the case of Grisham Nair versus State of Kerala, in Criminal Appeal number 1864 and 1865 by 2022 on 11/11/2022, held that the bench consisting of Justice B.R. Gawai and Pamadigantam Srinasimha, they held that the test identification parade will become inadmissible if the suspects were shown to the witnesses before the identification. So this is the important point you have to learn. Please remember, of course we know, even the test identification parade conducted in presence of the police, definitely it is also inadmissible. So you have to know the legal provision. The legal provision is Section 9 of the Indian Evidence Act, which says that the test identification period is admissible when the accused were not identified in the FIR stage. Right. So please remember, you know that test identification parade is not a substantive piece of evidence. So please remember, it is done during the course of investigation to support or to strengthen the prosecution case. It is only corroborative but not substantive. Please remember. So the test identification period cannot be held trustworthy in all the cases. Right. Now, as far as the present case is concerned, actually this happened in the year 2000. 22 years back it happened. Actually, at the time, what happened is the government of Kerala or state of Kerala decided to delink the pre-degree course from the degree course. So they wanted to delink the pre-university course from the degree courses, and actually they start 7th form or +2 at the school level. Of course, as youngsters, you may be able to understand or not, but when we were youngsters, it was there. We studied PUC, that after the so-called, we passed SSLC, Secondary School Leaving Certificate. That means 10th class, after 10th class, there is a class called as 11th class or SSLC. We passed that, then we have entered the college where we studied pre-university course, PUC. Then we have gone to the degree. At the time itself, in Jilla Parishad High School, Repalli, there was a class called as 7th form. That means 12th class is also there in high school level itself. So this is what is called +2. So Kerala decided to delink the so-called pre-university degree course from the degree level and attach it to the state school level. And the proposals actually they were actually leaked out, and immediately the protests started. So please remember, on 12/7/2000, actually, the mob of about 1,500 persons, in which the so-called Grisham Nair and 32 others, they were identified. Actually, they have hatched up a conspiracy, and as a part of the conspiracy, on the next day, that is on 13/7/2000, they have gathered about 1,500 protesters. So they went to the government secretariats, damaged the buses, damaged the they have actually glass panes, and ultimately when the staff of the RTC actually come in confrontation with them, in the result, one person by an RTC conductor by name Rajesh, he died. It has become a murder case. 120B, 302. Actually, first it was 307. 143, 147, 148 and 307 IPC, and also Section 2, Section 3, Clause 2, Subclause E of the PDPP Act, that is Prevention of Damage to Public Property Act 1984. Of course, among the 32 others, some people were almost 19 people they have been let off, and 4 plus 3, I think 7 persons have been convicted for life, another place, basing on what? This is more important. You know, this is a huge gathering. It has to be identified. The identification was conducted by the police, got conducted by the police, as a result of which these people were convicted. But when matter came to the Supreme Court, the argument on behalf of Girisham Nair is that the identification was done actually by the police. So before identification, they have taken the photographs, they have videographed the arrested persons, and from the cabin of the investigating officer or from the cabin of the CI, the accused was shown to them. Even though the test identification was conducted in the jail premises, since it is located nearby, then the accused was shown to him. These points are sufficient for the Supreme Court to say that the test identification, which was supposedly done on 31/7/2000, it is not done in a perfect manner. Therefore, the evidence is inadmissible because, number one, the photographs were taken. That's why. Now I will tell you, you might have seen, and our friends also commented. So whenever the police shows the arrested accused persons, their faces are covered with a mask. Why, sir? So what is the use of seeing a person in a mask? If he is shown to the public, they will have some knowledge. Oh, that fellow is a criminal, he is a rowdy, he is a bad fellow. We must be aware of him. But please remember, Supreme Court guidelines that the identity should not be established. So if the police show the face of the persons, you cannot conduct any test identification proceedings, right? So the allegation is that their photographs were taken and there is a delay in conducting the test identification parade also. So please remember, therefore, the test identification conducted by the police, it has become totally useless. Now the Supreme Court actually, please remember, they have opined that the conduct in which the test identification parade was conducted is actually vitiative. So it has vitiated the entire process. Therefore, the appeal allow the accused persons acquitted. Happily, they have gone home. So what you have to learn from this case is, so if the police officer wants to get the test identification parade conducted by a magistrate, so he should take these three precautions. Number one, he should not take photographs of the accused persons. And secondly, he should not take any video. Thirdly, he should not show them to the witnesses before the test identification parade. Otherwise, because if any doubt is there, so benefit of doubt, to whose side it has to go to the accused side. Same thing happened. So the police officers, if anybody sees, they must be very, very careful on seeing this case law. As advocates, as law students, please read the case law and enrich your legal knowledge. This much I can tell you. Thank you very much.